Hello again and welcome back. For those of you who did not attend our first session, I'm Kerry Kazuki with 501 Commons. We are a Seattle-based nonprofit that provides management consulting services to more than 1,000 nonprofits per year across the country. We are partnering today with 501c services for 3 hours of nonprofit-specific content. Welcome to our second hour with Bruce Sarchet, who is an attorney with Littler. Bruce is going to present his latest webinar in a series of 4 that he has produced on employment law changes created by the COVID-19 pandemic. As you may already be aware, Bruce's presentation has been pre-recorded, but Bruce is standing by monitoring the chat feature of our webcast to answer any of your questions. We expect Bruce to get a lot of hard questions, and he may not be able to address every single one, but he has promised to do his best. For those of you hoping to learn HRCI or SHRM credits, please record the 3 keywords that will pop up periodically at the bottom of your screen, like the one below me now. If you miss a keyword, please feel free to use my name, Kerry, K-E-R-R-Y, as a placeholder for one of your three required submissions. Submit your keywords using the survey link at the bottom of our screen. And remember, if you are attending multiple sessions, we only need 1 survey with all your keywords listed. You don't need to send us multiple surveys. Just 1 will do. Lastly, this session slide deck will be sent to you via email later this week, so everyone attending will get a copy. From all of us at 501 Commons, please enjoy Bruce and his program.
Hello and welcome to our second webinar of the day. I hope you found the first one to be informative and enjoyable. My name is Bruce Sarchet and I'm an attorney, a labor and employment law attorney. And those of you that have been on my 501c webinars before know that typically every month we take a look at COVID in the workplace. What's new, what's happened in the last month, and we're going to repeat that again here for July. Our first webinar together was all the way back at the end of March when we were just starting to shelter in place, and we covered a number of important and new topics, mainly dealing with how do we sort of close down our businesses and how do we send employees home. Then in April, we followed up with another webinar and brought everybody up to speed, and businesses were just about to start reopening. By the time we got to June, we were doing reopening pretty much everywhere. And we talked about how you bring employees back to work. And in fact, there's a series of maps. I've been saving them from our past 501c series of webinars. And here's the one from May the 1st. And you can see that most of the country was shut down still on May the 1st, just about to start reopening. And then jumping to June the 5th, we see that most of the country now is reopening or reopening on a regional basis. And then if we go to last week, I know we're watching this, it's being recorded. I'm actually speaking to you from last week, July the 16th, we see that everybody's reversing, that the country is sort of shutting down again. The coronavirus is not going away. Some people out there might have forgotten about it, but it didn't forget them. It's still out there. It's still doing its thing. And so nonprofits across the country still have to adapt. So our agenda for today, we're going to take a look at what's really been happening the last 5 or 6 weeks with regard to COVID in the workplace. We'll run through all of the things you see on the screen here. And I will take your questions via chat as we go along. This is a recorded webinar, but I'm watching it with you, and I can answer questions that you send to me as we work through the material together. Now, I'm a lawyer, and I get a little uncomfortable if I talk too long without a few disclaimers. We're going to go over a lot of information, and we won't be able to cover everything. In fact, we can't cover everything because we don't know everything. And here's my favorite. This webinar does not substitute for the advice of counsel. All right, first of all, public nuisance lawsuits. These have been in the news lately. For example, employees at a meat processing plant filed a lawsuit saying the workplace was unsafe and they were unable to take their sick leave. And then another group of employees at a restaurant basically brought the same sort of claim, saying that this was unsafe. And the legal theory advanced is this is a public nuisance. And then the same thing again in June. Another one of these broke on the headlines. And I'm not using the company names here on purpose. But there are good defenses here if you happen to get hit with one of these lawsuits, because workers' compensation, depending on the state in which you're operating, but in most states, workers' compensation is the sole and exclusive remedy if an employee is hurt on the job. Then you'd also be able to show that you were in compliance with CDC guidelines or local or state health and safety ordinances. Then there's the question of if someone actually has the coronavirus and COVID-19 results from it, what caused that? Did they really get it at your workplace, or maybe was it at that 4th of July barbecue that they went to? And then also arguments that you just couldn't control the situation and that such claims must be void as against public policy. So there are a few of these percolating out there. It's really popped up just in the last 5 to 6 weeks. If you're hit with one of these lawsuits, of course, call your counsel and call your insurance carrier as well. So segment number 2 under the Families First Coronavirus Response Act, we've seen the Department of Labor starting to enforce this new law. Remember, it's only been around since about the middle of March. It provides for emergency paid sick leave and emergency family and medical leave, and gives a payroll tax credit to those businesses, those nonprofits that provide this leave. Well, there was a 30-day non-enforcement period at the very start of this leave, and that's long been expired. The Department of Labor is now out there enforcing this law. If you go to their website, it seems like almost every day they've got a new press release on a new enforcement action. They've also rolled out a new web tool for employees. You can look at this and determine whether or not you are eligible for emergency paid sick leave or emergency family and medical leave. Supposedly there's an employer tool coming soon. Maybe by the time this webinar is broadcast, if we go to this webpage and hit the refresh button, we would find the employer tool, but right now it's only for employees. Now remember, emergency family and medical leave is available to employees when they can't come to work because their child's school is closed and nobody else is available to take care of the child. Well, as we moved from spring into summer, the question started to come up, what about summer camp? My kid was supposed to go to summer camp and they canceled it because of COVID-19. Now I need to stay home and take care of him. Does that qualify for emergency family and medical leave? And it may. It may. The Department of Labor seems to be taking a rather sort of generous approach to this question. More information is available online at the Department of Labor website. So, enforcement of these new laws. Many employers are used to being what I might call the sick leave police. They want to make sure that employees are not abusing their sick leave, that they're really entitled to it. So you might be tempted when an employee comes to you and says, hey, I'd like to take some of this Families First Coronavirus Response Act leave. I've checked the old DOL web tool here, and according to that, I'm eligible, and so I'd like to take it. You take a look at that and you say, nah, I'm the sick leave police here. I'm not necessarily sure you are entitled to it. It's not covered, so you can go home. It's unpaid, but you can go home. Instead of saying that, let me submit to you that this may be a time, instead of saying no, look for a way to perhaps say yes. And then you ask, Bruce, what are you talking about here? I'm the leave of absence police. It's a pain when people don't show up for work, and we want people to show up for work, and I want to make sure that they actually qualify for it. So why would you say, look for a way to say yes? Well, my friends, I say that for 4 reasons, or 4 things to think about. Number 1, it is disruptive to have people off the job. I get it. That's difficult. You got to juggle everything. But let me submit that it is also disruptive to have to respond to a Department of Labor investigation and pay fines and fees as a result. Remember, you get a 1-for-1 payroll tax credit for giving these leaves. The thinking is that the government is paying for these leaves, not the not-for-profit organization. And it's a payroll tax. Everybody pays payroll taxes, so you get some back on there. And so maybe that's another reason why to say yes. And then my final thing for you all to think about. These leaves are only in effect until the end of this calendar year. They go away. I predict that as the holiday season starts to roll around and we look to the end of 2020, we're going to see a lot more of these claims for these sorts of leaves of absence. So to some extent, if you grant these leaves now, then you may be sort of feathering them along the calendar so you're not hit with a big rush of these kind of leaves at the end of the year. So before you say no, in these circumstances, I think maybe we need to think about looking, can we say yes? Can we go ahead and grant this kind of leave of absence? Third segment we'd like to talk about today is what's new with regard to face coverings. We weren't talking about this at all way back in March in our first webinar together, but now it's all over everywhere. What about customers? Those of you that have public-facing businesses, a customer or a visitor comes in and they don't have a face covering on, and you want to have face coverings in your workplace. And so you really need to sort of be the face covering police, right? And you can ask them this last question. A lot of people look at that question and say, you mean I can ask about a disability? And in these circumstances, yes, you can. Is something wrong? You have some sort of disability that prevents you from wearing that face covering. And if they say yes, then you have to really treat them almost like an employee under the Americans with Disabilities Act and engage in this interactive process with them to see if there's a way that they can visit your premises without causing an undue hardship to your operations and still maintaining health and safety. So another thing to think about, we're seeing face coverings become more and more a sort of a volatile topic in our society, and we've seen the news reports about people getting agitated and upset because of these requirements. But we've also seen all of the epidemiologists, that's a nice big word, saying that face coverings really work. They not only prevent you from giving it to somebody else, they prevent you from getting it in the first place. And it's pretty logical. I mean, if you just think about it, if you can breathe the stuff in, if you've got 3 layers of cloth over your nose and mouth, then it's probably going to help. And pretty much all the health experts agree to that. The other thing I'm seeing out there in public, so I know that workplaces, employers, and businesses are facing this as well, is all the old, I'll wear it over my mouth, but not over my nose, right? Well, that doesn't work. You have to get it all the way over both your mouth and your nose for it to work. So while you might listen to Bruce and not be so much the heavy hand leave of absence police, I think that enforcing face covering rules is really important. I had this call with a client just today. The employees were saying, once I clock out and I'm not on the clock, then you can't control me. So I'm not going to wear my face coverings on my breaks. What do you think about that? Well, I said, what I think about that is nonsense. Safety first. Safety, safety. You're in our building. We have these safety rules, and it's about your coworkers. It's not just about you, it's your coworkers. You're creating an unsafe environment for them. So yeah, clock out. That break time is yours, but you still have to comply with our face covering policies, even when you're on your break time. When you're walking from the building to your parking lot and you get in your car and you close the door on your way home, that's when you can take off your face covering. I guess some people really do not want to wear these things, right? So there's fake face mask exemption cards out there. I mean, people think of everything. And you can go on the internet and print up a little card that says, I'm exempted from wearing a face mask. And apparently this is such a problem that the Federal Department of Justice on their website has issued a bulletin saying, this is a fraud. These are fakes. There's no such thing as a I don't need to wear a face mask exemption card. You just can't have one of those in your wallet. It doesn't exist. So if someone presents one to you, go to the DOJ website, print this up and say, no, 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 no. Apparently some of these cards actually use that little logo that you're seeing up there on the screen, and it's printed right on the card. It's a fake. Don't go for it. OSHA, our Federal Occupational Safety and Health Agency, you just heard about them, I'm sure, to a pretty good extent in the webinar right before this one, has issued guidance on face coverings. You should check that out as well. They go into detail about the different types of coverings. And at the end of the day, though, they're saying not required, but encouraged. So stay tuned on this one. It's really evolving, and it's sort of almost the middle of summer now, I guess. I bet you by the end of summer, we'll see even more developments in this area as well. So on to segment number 4, what's new with regard to COVID-19 testing in the workplace? Well, back in April at our webinar together, I showed you this slide. And this slide says employers could actually test their employees for the COVID-19 to see whether or not they're infected. That is a little bit, it was at the time, I should say, a little bit surprising. It's like the EEOC saying you can give a medical test to an employee. And yeah, they did. They also said, though, that testing needed to be accurate and reliable. So in that webinar in April, this was my next slide. Is the testing really accurate and reliable? And there's basically 2 types of testing out there on the market today. There's a third one that's sort of in development. It's called antigen testing, but you really can't access that today. You can access these 2. There's basically the DNA test. That's the Q-tip, and you wiggle it around up in your nose and then your other nostril, and they test it. And there's the antibody test, which is a blood test. And the CDC is basically saying this about the antibody test. It may show that you have the presence of the antibodies, but that may or may not mean that you actually have COVID-19. So I'm not a doctor. I don't even play one on TV. But to me, if a test says it might or might not, then that's not a particularly reliable test. And guess what? The EEOC, even though they're not doctors, they agree with that assessment. So that test for antibodies is not permitted under the EEOC. The test for DNA, RNA, the nasal swab, is permitted. And this is guidance that was just issued by the EEOC 1 month ago in the middle of June. Also on testing, something new has come up in the nomenclature. It's called surveillance testing. Surveillance testing. And I'm a big fan of euphemisms, I mean, as much as the next guy, but I'm sort of looking at this surveillance testing and I'm thinking, I know a different word to use to describe surveillance testing. In California, for example, our DSS, Department of Social Services, has issued this bulletin for adult and senior care program licensees, requiring what's called surveillance testing, 10% of the workforce every 14 days. These are folks that just come to work and they're doing their job. They're not coughing. They're not sniffling. They don't have a temperature. They don't feel achy. They're coming to work and doing their job. And you pull them out of line, 10% of them every 14 days, and you give them a test. And you give them a test. And I get it. I know where this Department of Social Services is coming from because, you know, we've seen the news reports from the nursing homes. It's tragic what's happened in some of these facilities, just absolutely tragic. And so we want to try really hard as a society to prevent those sort of things from happening. Surveillance testing, though, in the employment context, to me, really seems like just another word for random testing. It's just picking people at random and saying, go get your test. Well, in California, we don't like that too much. We're not big fans of random drug testing. But on the other hand, if you don't follow these recommendations and someone catches the virus and you become one of these clusters, well, that's not going to be very good either. So this puts you in a difficult situation. Los Angeles City and Los Angeles County have similar surveillance testing requirements for skilled nursing facilities and long-term care facilities. So check your local jurisdictions, check your local health orders. Surveillance testing is sort of starting to come in around the edges of American workplaces, and tomorrow maybe it will be your turn to engage in this, what I really call random testing. Okay, that's the update on testing, and let's move on now to COBRA, the Consolidated Omnibus Budget Reconciliation Act, which is the craziest name ever for a law dealing with the continuation of medical insurance when you leave employment, but that's just the way our lawmakers write the laws, and so here you go. The Internal Revenue Service and the Department of Labor issued guidance in early May, and I apologize to you, my dear viewers, on the 501c webinar program, and I've been doing these every month. This should have been in our June update. This one flew beneath even my radar, but I'm bringing it to your attention now. The key deadlines in COBRA have sort of been put on hold until the end of this national medical emergency. They've got 60 days to elect COBRA, just like they always have, but the 60 days is not running yet. It doesn't run until the end of the emergency. And guess what? If they haven't paid, you still have to cover them. That's right, under this emergency guidance. And that can be pretty challenging, because I don't know if you've ever had a COBRA event yourself. I personally have not. I've been the same law firm for 30 years now. I have not changed jobs in a while, but my kids have, and I've seen the COBRA bills, and boy, they add up quick. 1 month, 2 months, and wow, you're over $1,000. You're over $1,500. This stuff is expensive, right? So can you imagine if you don't pay the COBRA bill for 5, 6, 7, 8 months, as long as this emergency goes on? My hand's going all the way to the other side of the computer screen. It's so far into the future. Boy, I think people are just going to say, I can't pay. I don't got $10,000. I can't pay for those medical insurance premiums all the way back there. And then what do we do as a society, as an insurance company, as an employer? I don't know. It's something to think about that's maybe coming our way in the future. I really think we're in for a prolonged economic recession. It's going to be a while before we dig out of this. And things are going to start, they're not getting better out there. I mean, people have been laid off from work. They were recalled back to work. Oh, the restaurant's open again, come back to work. And now guess what? It's shut down again. And those extra unemployment benefits from the federal government, will they be around at the end of the summer or will they not? And that's going to have another impact. It's real. People are going to be hurting. People are going to be hurting. So that's the update on COBRA. Sorry, wish that I had a more upbeat and lively assessment of it, but that's what we're dealing with. Let's take a little bit deeper dive back into the whole question of working from home. Because as we see businesses shutting down again, I think we're going to need to really take a look at this in more detail, and a lot of businesses are doing just that. And I have spoken to you before, dear viewers, about the work from home scenarios, but my thinking is evolving. And here's the latest evolution. When we talk about telecommuting, when we talk about work from home, let's try to put it into one of 3 categories. Mandatory. This is where you're shutting your doors and you're saying, don't come into work. You can't come into work. You work at home. Voluntary. This is where you say, our office is open, our plant is open, our warehouse is open, but if you want to work from home, you can, fill out the application form, do this, do that, and we'll decide whether or not we will grant you that privilege of working from home. And then a third category, which I call accommodation. An employee comes to you and says, I don't want to work, I can't work, I'm scared I'll catch the virus, I've got asthma, et cetera, et cetera. You need to engage in an interactive process and see whether or not work from home can be a reasonable accommodation. So let's play this out just a little bit more. A couple of scenarios to run through with you. The employee comes and says, I'd like to work from home. So this is really in the scenario, not where it's a mandatory program, where your office or your warehouse or your plant is still open. Human resources can certainly say, why? Why do you want to work from home? Well, the employee then replies with, I'm afraid I might get infected. It's a legitimate fear, folks. People are really afraid that if they go out in public, not everybody, but there are people who don't want to go out in public because they don't want to get infected. A business can definitely respond as follows. If your doors are open, hey, it's safe here. We're doing what we're supposed to be doing. You got your social distancing, you got your mask, we got your hand washing stations, we got your hand sanitizer, we got only one person on the elevator, we got this, and nobody in the lunchroom, etc. Plexiglass everywhere. It's safe, but you probably still should engage in the interactive process rather than just saying, you got to come to work. No questions. These are people you need to talk to. They're scared, right? They're scared and they don't want to come to work because they're afraid they'll get sick. Change the scenario just a little bit. We go through the same first couple of questions, but then they come up with this. I'm over 65, or I have type 1 diabetes, or I have asthma. I'm in a high risk category and I'm afraid I might get infected. You can still say it's safe here, but then you really probably should engage in the interactive process. In fact, I don't want to steer you astray. Scenario number one, I really think you should engage in the interactive process. Scenario number two, I really think you should engage in the interactive process. Scenario three is where they actually say, I've got something other than just I'm over 65. They say, I actually have type 1 diabetes, not just I'm over 65 or not just I'm pregnant. Then definitely you must engage. You must engage in the interactive process. And those of you that know the Americans with Disabilities Act forwards and backwards know that an employer is obligated to provide a reasonable accommodation that will allow an employee to perform the essential functions unless such would cause an undue hardship. Well, I think employers used to be able to argue that working from home might be an undue hardship, but with the mass migration of white-collar workers to work at home that we have seen here in the spring and summer of 2020, I think it's going to be more and more difficult for an employer to say, oh, you can't work from home because that's an undue hardship under the ADA. A few other considerations about working from home: wage and hour law. If you've got non-exempt employees, those employees that are entitled to overtime pay, then you need to worry about these things: keeping track of time, keeping track of overtime, making sure they get their meal and their rest breaks. And for all employees, exempt and non-exempt, expense reimbursement, home internet, on and on and on, the cell phone, all of these things, employees may have a right, depending on state law, to reimbursement from their employer for these expenses. Other issues: safety, injury reporting, and so on. But let me back up to this slide on expense reimbursement. I've also had a little evolution in my thinking here, and I think we've talked about this topic before on one of our prior webinars. But here's my latest thinking. Pay something, okay? Pay something. $10 a month, $20 a month, some amount. Because I think if the lawyers out there, the plaintiff's lawyers, are looking to bring a lawsuit for failure to reimburse for expenses, I think they're going to go first to those businesses which are paying $0 for this. If you're given $20 a month, you're probably not as attractive as a target. It's a little bit, I think, like that club, they sell that you can put in your car. You put it on the steering wheel, you lock it. It's got this big iron bar going across your steering wheel. Is that going to stop someone from stealing your car? No, the people who steal cars, they know how to beat the club, I assume, right? But it does make your car a less attractive target, right? Because they've got to go through the whole stupid club to steal your car. So maybe they look at the Honda Accord down the street instead of your car. That's a good thing, and it's doing what it's supposed to. This nominal payment, if you would, $20 a month, is going to do the same thing with regard to claims against you for expense reimbursement. If you've got people working from home, think about this. It's state law specific, but my advice is pay something and you will be an unattractive target. So going back to the start of this segment, we had mandatory, Bruce told us about voluntary, and Bruce told us about accommodation work from home scenarios. Does it really make a difference? And I would say it probably does. It probably does. For example, if you're saying you must go work from home, then I think maybe your reimbursement for expenses needs to be a little more generous, and you need to be a little more lenient, perhaps, with regard to the types of expenses that you're reimbursing for here. You see, I've got a number on the list, and some might be more obvious than other. If you've got a mandatory work from home program, maybe a little more lenient with regard to the categories of types of things, expenses, which can be reimbursed. If it's voluntary, then you might also want to be a little bit more watching, making sure, hey, are you really doing your work? Are you keeping good time records, et cetera? Because you want to prevent abuse and theft of time. And then finally, I think you treat accommodation basically the same as mandatory. You're sort of saying, this is where you're going to work. So it's not something the employee is necessarily choosing to do, not sort of a benefit, but something that is really just a part of doing the job. So that's a little bit deeper dive into work from home. It's going to be around for a while, and we're all going to have to continue to deal with it and adapt it. In case you couldn't tell, I'm working from home right now myself. All right, on to segment 7, the WARN Act. And the WARN Act, by the way, why do I have that caution tape up there, Bruce? What's that caution tape for? The caution tape's up there because WARN is very complicated. And even though I gave legal disclaimers at the start of this program that this seminar, this webinar does not substitute for the advice of counsel, I have to really caution you on this slide, because this is perhaps the most gross oversimplification of an employment law in the this slide is the most gross oversimplification of an employment law in the history of Western civilization. I'm knocking off so many corners, it's not even funny. But WARN in general requires this advance notice of a plant closing or a mass layoff. There's federal laws, there's state laws. You need to be aware of all of them. Literally, we could do a 3-hour webinar just on WARN itself. But there's this interesting twist in WARN. A furlough or a layoff of less than 6 months is not an employment loss, so you don't have to give notice. But if it goes more than 6 months, then you should have given the notice way back when. It's retroactive. So if you've hung your hat on this bullet number 1 and 6 months is approaching, you better get on the phone with your lawyer pretty darn quick and work out a strategy and an approach, because you could have a retroactive, a look back failure to give adequate WARN notice. All right, I think this is our last segment together, and sorry to see us drawing to an end, but there are a number of states which have passed what might be called safe harbor laws, limiting liability of businesses when a person is exposed to COVID, a visitor, a customer, or an employee. We've seen federal bills introduced as well. The Senate apparently is going to be taking one of these up fairly soon. The idea is, I think it really ties back to number 1 that we talked about today, these public nuisance lawsuits. And remember that bullet on the one slide where I said causation? What really causes this? And there's a lot of coronavirus that's out there that's swirling around. You can get it anywhere, not just at the workplace, not just when you're shopping at the furniture store. So maybe this government needs to step in and say, all right, well, we're going to limit businesses' liabilities. They've done it in these states, and basically what these laws do is provide some sort of immunity, and there's a different category. They're all state by state specific, and basically if you're acting in good faith and following the guidelines, then you're going to have immunity. And as I mentioned, the federal level, Congress is considering this. The Senate apparently is going to take it up soon, so stay tuned on that. And that, my friends, is our update for COVID-19 in the workplace. We've been publishing like mad on this at Littler Mendelson over the last few months. That's the law firm where I work and have worked for 30 years. All we do is labor and employment law. And when you get a copy of the slides, you'll be able to cut and paste these links and go to littler.com for all of the latest on our publications. So thank you, my friends, for our time together. I hope you have found it to be worth your time and valuable information for you. I look forward to seeing you again at another one of these 501c COVID-19 in the Workplace Update webinars. Stay safe and good luck to you all.